a Cleveland Jewish News production.
Welcome back to Aliza, her story. Welcome to a different chapter, both in time and in the storytelling we've been working to share with you. If you've been following Aliza Sherman's story for a while, maybe like us, you're now waiting to see her accused murderer, Gregory Moore, on trial. Welcome to a new version of Waiting. This is the part of the story Law and Order usually blows right past, skipping from crime to arrest to conviction in the tidy course of an hour. While we've seen enough episodes to consider ourselves armchair experts on such high-profile trials, we likely don't have to tell you, real life just doesn't work like that. In the months since Moore was arrested, news from the Cuyahoga County Justice Center has been a slow drip of small details and lots of filings. In the pages of paperwork, it can be hard to follow, hard to understand what we've learned and what we already knew about Aliza's life and death. It can be hard, for most of us, to see how the case against Greg Moore is taking shape. Most of us, but not all of us.
As I explained to people, there's this French painter called Seurat, and he believed in his method of painting was pointillism. So if you look at his paintings real close, all you see is dots.
That's Larry Zukerman, co-managing partner of Zukerman Lear Murray Brown here in Cleveland. He's a veteran defense attorney who's lived and breathed these type of cases for 40 years. He has thoughts on this case.
But as you step away from it, you see this beautiful painting. And here you're going to see little dots, little pieces of evidence. I think when you step away, you're going to see murder.
Zukerman is no stranger to high-stakes trials. In fact, he relishes them. He welcomes complex cases and enjoys winning them. His firm has defended clients, those facing serious charges like Greg Moore faces, and successfully gotten those charges dismissed. Zukerman is strategic, meticulous, and thoughtful. He's also direct.
I'm not a jury here, but when I look at this evidence, I see no other explanation for what occurred here.
I'm Sarah Shookman.
And I'm Mike Butts. You're listening to Aliza, her story, the Cleveland Jewish News podcast about Aliza Sherman's life, loss, and legacy. Welcome to episode 7. Sarah and I are both journalists who for years have reported on Aliza's story. We started this podcast in early 2023, 10 years after Aliza died, and worked together, and with Cleveland Jewish News and Jennifer Sherman, to bring you a deeper, better understanding of who Aliza was, to understand how she lived, not just how she died, and to share the change the Beachwood nurse and mother of 4 has inspired. The next chapter began earlier this year when Greg Moore was arrested and charged with Aliza's murder. Our goal is to honor Aliza's life and legacy with transparency on the process of pursuing justice. The trial is currently slated to begin in late March 2026. That could change. As we wait and wade through pretrial motions and hearings, we sat down with Larry Zukerman to try to get a better understanding of the process and a better idea of what to expect.
It's horrendous what happened to Aliza Sherman. Unbelievable, quite frankly. I'm Jewish. I live in Beachwood. My kids went to school with her kids, and it sent shockwaves through our community. This was the night before Passover.
Zukerman knew the Sherman family, and he's dialed into Northeast Ohio's legal community. He's familiar with the lead prosecutor and the lead defense attorney. He knows the judge who will try the case, and in fact, he knew Greg Moore. In other words, we think you'll want to hear what Larry Zukerman has to say.
But first, let's catch up on what's happened in the courtroom. Since you last heard from us in May, on the heels of Greg Moore's arrest in Texas, a lot has happened. Moore, a 51-year-old Sagamore Hills resident, was extradited from Williamson County Jail in suburban Austin to Cuyahoga County. He'd been there to visit his dying father. Now, he faces 10 criminal counts, 1 count of aggravated murder, 1 count of conspiracy, 6 counts of murder, and 2 counts of kidnapping. Assistant Cuyahoga County Prosecutor Kevin Filiatro will prosecute the case. With an incredible volume of evidence collected by Cleveland police and the Ohio Bureau of Criminal Investigation at his disposal, the burden to prove Moore's guilt is his. Meanwhile, Moore hired a defense team of John Paul Ryan and Catherine H. Jackson of the firm Ryan, Ryan & Ryan in Dayton. Those attorneys entered a plea of not guilty on Moore's behalf during an arraignment in Cuyahoga County Common Pleas Court.
The morning of May 28, 2025, Moore appeared by video feed for his arraignment. That's a hearing at which a defendant is informed of the charges against them and asked to enter a plea. It's also when a judge sets bail on any conditions for their release. Moore was dressed in an orange jumpsuit at the neighboring Cuyahoga County Jail.
Good morning, Mr. Moore.
Good morning, Your Honor.
Jennifer Sherman addressed the court that day to make the case that Moore's bond should be considerable.
Your Honor, thank you for the opportunity to speak today. My name is Jennifer, and I am here today as the daughter of Aliza Sherman, who was brutally taken from us in a crime that has devastated our family and the community. Greg Moore stands before this court, charged with the kidnapping and murder of our mother, his own client, a woman who trusted him, a woman who he was duty-bound to protect and advocate for. Instead, he allegedly betrayed that trust in the most horrifying way imaginable. If a person is capable of such calculated violence against someone he had a professional obligation to defend, one must ask, what else is he capable of?
In a memo filed to support bond, his attorney said Moore had spent the past several years working in construction. They said he was still living in the home he and his wife purchased in 2006. Described him as a practicing Catholic, a father trying to support his family, with deep ties to the region. They argued he was not a flight risk.
This man stayed in the community this entire time. He hasn't moved, he hasn't left, he hasn't done anything except for stayed in the community and continued with his life.
That's Moore's attorney, John Paul Ryan. Judge Deborah Turner set Moore's bond at $2 million. To the surprise of some, Moore posted that bond initially without any of the restrictions you'd expect of an accused murder suspect. In response, Aliza's family released a statement advocating for, quote, immediate necessary protections to be put in place. Family and friends later attended a pretrial at which Moore was placed on GPS monitoring and court-supervised release. Ultimately, Moore's trial was set for March 30th, 2026. Presiding over the case will be Common Pleas Court newcomer, Judge Kira Krivash, who was just elected in November 2024 and started on the bench in late December.
Let's take a closer look at who will be involved in this trial moving forward, and let's start with Judge Krivash. She won't decide whether Greg Moore is guilty or innocent. That's the responsibility of the jury. But she will shape nearly every other aspect of the case. She'll determine what evidence jurors can hear. She'll examine how witnesses are questioned. She is already ruling on motions that influence, limit, or expand the prosecution's case.
Good afternoon. We are here on case number 701663, the state of Ohio versus Gregory Moore. If the parties could please identify themselves.
Judge Krivash is responsible for keeping order in what's likely to be a high-profile, emotionally charged courtroom. And if Greg Moore is convicted, she will determine his sentence, likely in accordance with Ohio's sentencing guidelines. A judge's discretion can profoundly impact the tenor and tone of a trial. Prior to being elected a judge, Krivash served as a magistrate for the Cuyahoga County Court of Common Pleas Juvenile Division from 2021 to 2024. She has several leadership and service awards to her name, but is her relative lack of experience cause for concern? Larry Zukerman doesn't think so.
This isn't her first rodeo. She's a very smart, patient, wise individual, and she doesn't let people excite her. I mean, she's really got a very cool demeanor. And so I think she's going to handle these people well.
Zukerman should know. When he served as president of the Cleveland Metropolitan Bar Association, Krivash was on the board of directors. He described her as prepared, thorough, nice, and not someone who's going to get pushed around.
I think people are going to come in thinking that they may be able to easily persuade her, because I don't know if she's tried a murder case yet. But this isn't scheduled for trial until March of 26. But I think, people are going to think that she's easily persuaded. And she is one of the hardest working people I know. She is going to know the law inside out, backwards. She's going to be totally prepared for this, and she suffers no fools.
Sarah here, interrupting. You're hearing Zukerman bang his hands on the table for emphasis.
I mean, she's a very nice person, but she's the type of person where don't take her niceness for being a fool.
What about Moore's lead defense attorney, John Paul Ryan? We requested a sit-down interview with Ryan and his client, but our request went unanswered. Ryan is a veteran defense attorney. His firm has a long reputation for defending clients charged with serious, violent crimes. The work of a defense attorney can be controversial, but it's a key part of the justice system. He'll work to protect Moore's rights and to raise reasonable doubt whenever possible.
So we'll put our case together. We'll implore or get the experts that we need to take care of this case, and we'll present our case to this jury. I want to get the information. I want to make sure, that, as you said earlier, that we're working off evidence. Firm, strong evidence. Not politics, not conjecture, not just an idea or an imagination as to what happened, but actual evidence. That's what we're looking for.
That was Ryan speaking to a gaggle of reporters after Greg Moore was arraigned. Zukerman is less familiar with Ryan. After all, he's based in Dayton, but has a connection.
I knew his dad. His dad and I were founders of the Ohio Association of Criminal Defense Lawyers with other people. Dad's a great lawyer, phenomenal lawyer, and from what I understand, Mr. Ryan also is a great lawyer. There's nothing better than watching two talented lawyers go up against each other. You learn. So, I think Mr. Moore is going to get great representation here.
Innocent until proven guilty. That's the cornerstone of American justice. And it means the burden lies with the state to build a case strong enough for the jury to have a clear decision. Kevin Filiatro, an assistant prosecutor for Cuyahoga County, has the task of showing the jury what happened beyond a shadow of a doubt. Filiatro is part of the major trial unit and is known for handling high-stakes cases. In seeking justice for Aliza, he's working closely with investigators from the Ohio Bureau of Criminal Investigation, or BCI, which took over the case from Cleveland Police years ago. In court, it's Filiatro's job to present that evidence clearly, weaving details into a narrative the jury understands and believes. He started laying that groundwork at the arraignment.
This defendant, Your Honor, planned this ahead of time, obtained the means with which he did this crime. Those means are also means that he used to avoid leaving evidence of his crime. That evidence that he sought ahead of time to not leave behind is the same evidence that clears the person that everyone thinks did this crime, which is Aliza Sherman's husband. He did not. And this defendant sought for, after this crime, he lied to the police. He hid evidence from the police. He got rid of the phone that he used to commit this crime with. And he has lived for 12 years amongst us with everyone believing the husband did this, and that's not true.
The volume of evidence and its specificity dictates how the narrative comes together. That includes DNA evidence and digital forensics, of course, but the smallest details as well.
If you look through the evidence here, one of the items that Mr. Filiatro provided in his discovery to the defense was a receipt from Heinen's that Aliza, from the night before when she was shopping for, the last time she went shopping for a Passover Seder. The receipt is in the evidence that the state intends to use against Mr. Moore.
We asked the Cuyahoga County Prosecutor's Office to speak with us, but they declined because the case is pending. Zukerman, however, knows Filiatro well.
I've known Kevin for probably over 25 to 30 years. He was an assistant prosecutor. He was a floor prosecutor. Then he went to the U.S. Attorney's Office and came back here. And he is a hard worker. He is thorough. He is a great trial lawyer. And so I think it's, if I could pick a trial to watch this year, this is the one I would watch. Truly, it'll be two equals, battling it out.
There's another attorney, actually a former attorney, Zukerman knows a bit about. That's Greg Moore.
Well, I knew him when he started working for Stafford's, and he spent his entire career there.
You might recognize the name. The Staffords, as many in Greater Cleveland refer to them, are the brothers and attorneys Joseph and Vince Stafford behind Stafford Law Company. Aliza hired Joe Stafford in 2011 to represent her in her contentious divorce from Dr. Sanford Sherman. But in March 2012, Joe was suspended by the Ohio Supreme Court for violating 6 of the state's rules of professional conduct, accused of fraud, deceit, and dishonesty. Vince was also suspended for professional misconduct after a ruling he obstructed discovery and caused unnecessary delays in a 2006 divorce case. So Aliza's case fell to Moore. What were Zukerman's observations of Moore?
Hardworking, smart, good trial lawyer. He was prepared. He was poised. He was smart. He was articulate. The cases that I had with him, he was always prepared. Then there came a point in time that he started passing out in court and they would have to call ambulances for him. This preceded the bomb scares.
Perhaps carrying the caseload of Stafford Law Company was weighing on him. From the outside, his behavior seemed consistent with someone unprepared and overwhelmed. You might remember that in 2016, Moore was indicted on 16 charges, 9 of which were related to bomb threats he made from his cell phone in January, May, and July 2012 against courthouses in Geauga, Lake, and Cuyahoga counties. On the day of each of the bomb threats, Moore was scheduled to begin a trial.
Judges, I know Judge Karner in particular, would issue court orders that he couldn't come to court alone. He would have to have second counsel with him. So, so there came a point in time when, at least with Judge Karner, she was requiring him to have another lawyer with him at all times in case he had one of his panic attacks or had to be carried out in a stretcher. Because I think both Vince and Joe were not working at that time. And I think Greg was one of the only... No, I think Greg and 2 other lawyers were running the practice. But they have a busy practice. They did that. And I don't know that he could have kept up with the volume of work. And I think that's where the problem started.
In 2017, Moore pleaded guilty to 4th and 5th degree felony charges of inducing panic related to the bomb threats. At the same time, he faced 7 charges tied to Aliza's murder investigation and eventually pleaded guilty to a misdemeanor charge of falsification. In exchange, the remaining 13 bomb threat and murder investigation-related charges were dropped.
So you wonder, why would somebody who practices regularly in domestic relations court, who knows everybody there, the judges, the bailiffs, the schedulers, the court reporters, the other lawyers, why would somebody jeopardize these people's lives and safety by calling it a bomb threat? I mean, it's just outrageous. If you're not prepared for a trial, you're not okay. That's on you, but you shouldn't jeopardize the lives and safety of others. I think it's appalling what he did. What's interesting is that, and I'm not going to name the name of the person, but Mr. Moore called the bomb threat into a person who knew his voice. And she identified his voice. And his voice is very distinct. He's got a very low, deep voice. And, and she had over a decade of dealing with him, knew exactly, could identify him, and I believe identified him to the police and the prosecutors.
Many conversations I've had in the last few months have gone, okay, yeah, all of that stuff was crazy, and I can't believe he was doing that. And yet to jump from calling in bomb threats that, were not actual bombs to the murder of a client that he was responsible for is also a huge jump.
Is it?
I don't know.
A criminal is a criminal.
It stands out to me that what you said about him calling somebody whose voice he presumably recognized and who certainly recognized his voice seems to suggest a level of maybe carelessness. This doesn't seem careless at all.
Or hubris.
Or maybe, yeah, I guess that could be it too.
Above it all.
Yeah.
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 He's been going around enjoying life. Well, this family has suffered.
In 2025, Greg Moore spent 62 days in custody. His bond was set at $2 million. That's not chump change. Yet on July 3rd, only 5 weeks after his bond was set, every news station in town had footage of him walking out of the Cuyahoga County Justice Center.
Don't you want justice? Do you want justice for Aliza Sherman? You were her attorney.
That's the whole reason why this happened. You prepared for the trial.
You were her attorney. Don't you want justice for her still?
For her trial on your conscience at all?
What happened on that day?
Who helped you?
Casual observers were puzzled, but not Larry Zukerman. From his experience, there was never any question Moore would post bond.
His lawyer specifically asked for a $2 million bond. I was like, well, he's going to make the bond. There's a reason why, everybody does something. I knew, in my mind as a lawyer, I'm thinking, well, Brian asked for a $2 million bond because that's probably what Moore can post or somebody could post for him.
I was shocked at how low the bond was, and I knew they would make the bond. It was just a matter of timing.
Mm-hmm.
They didn't want us. I mean, so had I been the lawyer,
Yeah.
I would have just ducked and waited as they did a couple months, and then just post the bond on a Friday afternoon, so nobody would notice that somebody did notice. Mr. Filiatro noticed, and pounced on it.
It's important to note that bond is not meant to keep someone in jail. That's a common misconception. Rather, its purpose is to ensure a defendant returns to court for their trial. It's also worth noting that Moore's bond was a surety bond. Surety bonds are 3-party contracts. One party is the surety or insurance company, which makes sure the second party upholds obligations to the third party. The second party is the principal. They need the bond, and in this case, that's Greg Moore. The third party is the obligee. They require bond, and in criminal cases like this, that's the court. And like with most insurance policies, there's a premium to be paid. Often it's 10%, which in Moore's case amounted to $200,000.
Somebody has to pay a premium to an insurance company of $200,000. So that's, money you do not get back. So basically, a surety, an insurance company is now babysitting you, guaranteeing to the court that you'll come back to court. If you don't come back to court, the insurance company then has to pay the court $2 million. So what the insurance company does, they have underwriters. Insurance companies are not in the business to lose money. That's, they run the world, right? Not because they lose money.
There's an underwriter for the bond that says, all right, we will post the bond. But they have to pledge $2 million worth of collateral. Somebody had to pledge and have $2 million of liquid assets.
Who is that somebody? Well, after Moore's bond was posted, his attorney, Ryan, issued a statement saying in part that Moore was, quote, grateful to the citizens of Ohio and Cuyahoga County who assisted in posting his bond. They believe in him and his innocence enough to support him in this case. Zukerman, for one, is curious to know who those citizens are.
There's a lot of depth to what's transpired here that people just normally gloss over.
That's why we're here.
And it's just, I was just wondering who posted the property worth $2 million.
The state of Ohio v. Greg Moore is currently in the pretrial phase. You might have heard that term before, but what exactly does it mean? Well, to the casual observer, it might be difficult to pin down because the term pretrial seems to cover so many different court goings-on. And that's kind of accurate. The term pretrial refers to any court proceeding or activity that happens before a formal trial commences, whether in a civil or criminal case. It's a phase for exchanging information, resolving procedural issues, potentially negotiating a settlement or plea bargain, filing motions, and preparing the case for trial. Think of a pretrial as preparation, a scouting phase in sports. Whereas your team takes the field to practice its best, you're also watching film from your competitor, watching for the smallest details, the breadcrumbs that might hint at the other side's strategy. The Moore case is very much in the exchange of information phase, or, as Rule 16 of the Ohio Rules of Criminal Procedure describes it, the discovery and inspection phase.
Criminal Rule 16 basically says, give me everything you got. And Criminal Rule 16 says, with few exceptions, you got to give them everything. So Mr. Filiatro has been filing with the court all the notices of the information that he's provided to Mr. Ryan. And it's a lot of information. So Mr. Ryan is going to have to go through all of this evidence now and see if he is of the opinion that any of his client's constitutional rights have been violated. And if they have, he is then going to file the appropriate motions.
This work is done strategically, and there are all sorts of examples. In Miranda v. Arizona, the U.S. Supreme Court ruled that for a suspect's Fifth Amendment right against self-incrimination and Sixth Amendment right to counsel to be meaningful, the suspect must know about them. From that decision, what we know as Miranda rights were born. So let's say a suspect talks to officers as he's being arrested or offers some kind of statement during questioning while in police custody. If authorities purposely or accidentally skip reading someone their rights, the right to remain silent and so on, anything they learned from those statements could be excluded or suppressed at trial. Same would go for a search of someone's cell phone without a warrant. If the chain of custody on a piece of evidence is not protected, that evidence and its implications can be thrown out. Moore's defense team likely also has investigators who are interviewing witnesses and people who initially might have been the target of an investigation into Aliza's murder. The defense hopes to find mistakes made by authorities that can be exploited during the trial. Other research is happening now, too.
I'm sure that he's also hired expert witnesses to go through all the forensic reports from BCI and from the Cuyahoga County Medical Examiner's Office because, they both did different type of testing, both of which are going to be introduced as evidence at trial.
Speaking of tests, in the most recent pretrial development, Greg Moore's defense team asked for permission to independently test DNA found on a wristwatch near Aliza at the crime scene. The defense argued that the DNA found during the initial tests conducted by authorities is tied to an unknown party, which in turn might clear their client. Prosecutors opposed the request, arguing in part that the DNA has already been tested for other possible connections. But in late September, the state filed a single-line notice saying it no longer opposed the motion. Judge Krivosh granted Moore's team 90 days to complete the testing because, quote, it would necessarily extend all future dates in the case. Without opposition, Judge Krivosh approved the request.
These type of cases are very complicated. They require, somebody who knows what they're doing to ensure that nothing is left unturned.
If you watch court procedural TV shows or movies, you know that some of the most high drama moments come when star witnesses testify. Who can forget the Oscar-nominated film A Few Good Men? The scene in which Tom Cruise's Lieutenant Kaffee questions Jack Nicholson's Colonel Jessup became part of the pop culture lexicon of the day.
You want answers? I think I'm entitled. You want answers? I want the truth! You can't handle the truth!
The stakes are even higher when defendants take the stand. But if you're waiting for Greg Moore to take the stand, Larry Zukerman says, don't hold your breath.
Certainly, Mr. Moore is not going to take the stand and explain it away. So,
You can say that today, like
with absolute certainty, there's no way Mr. Ryan is going to put Mr. Moore on the stand. No way.
What's the thought process behind that? The strategy, I should say, as a defense attorney.
Well, first of all, defendants are shielded by the Fifth Amendment to remain silent, and that nobody can comment upon it or infer anything from it. So one of the jury instructions to a jury is that if the defendant doesn't testify, you can't think anything about it. It cannot be used as any consideration for determining guilt or innocence. And that's it's a precious right that the Bill of Rights gives us. I can't imagine that Mr. Ryan would put Mr. Moore on the stand and then have him subject to cross-examination by Mr. Filiatro with all of this evidence. I don't know of any defense lawyer that would put him on the stand, especially in light of his prior convictions and the resignation of his license to practice law.
As we look ahead at what else to expect in this trial, some might be wondering whether Moore will get a plea deal like he did back in 2017. Not only did that deal result in Moore pleading guilty to only 3 of 16 charges, the sentence he received was well below the maximum. If convicted of those 3 charges, he faced 3 years behind bars, including prison. Judge John D. Satula instead sentenced Moore to 6 months in Cuyahoga County Jail, 3 years of probation, and 350 hours of court-ordered community work service. The 6 months, or 180 days, of jail time were issued in connection to the murder investigation-related falsification charge, a first-degree misdemeanor. The first 90 days were served consecutively, while the remaining 90 days were served in 1-week increments over the 12 months that followed. Here's what that looked like from Zukerman's lens.
He had a very lenient judge on his first case. They say you win and lose your case in the arraignment room. We have 34 elected common police court judges, some of whom are the nicest, most lenient people in the world. Others believe that everybody should go to prison for the longest time possible. And then you have people in between. And Mr. Moore's judge on his case was one of the nicest individuals on the bench, the most lenient people on the bench. So, sometimes you can't pass up an offer where they're saying, well, I'll give you 90 days in the county jail. Sometimes it's an offer you can't refuse. And I think the evidence was overwhelming against him in those cases. And, he got a great result.
It's hard to predict what happens next. As for Moore's current case, a plea deal is possible, but Zukerman thinks it's unlikely.
This is a murder case. Any murder, kidnapping, any way you slice it, if he took any deal, he'd die in prison. Unless they offered him just an amazing deal. Tell us who your co-conspirator was and, we'll give you 10 years, something, there's no way that's happening. But I'm just giving you an example, of how something could be, a lesser offense. We'll let you plead guilty to involuntary manslaughter. Let us know who your co-conspirators were, and you'll get out. You won't die in prison.
Speaking of co-conspirators, that's another facet of the case to watch closely. One of the charges against Moore is criminal conspiracy. By definition, criminal conspiracy is an agreement between 2 or more people to commit a crime, most often a felony. The Ohio Revised Code stipulates that to convict someone for conspiracy, it must be proven that the accused or their co-conspirator carried out at least one substantial overt act in furtherance of the conspiracy. The crime in question doesn't actually have to be committed. Conspiracy just means an agreement and an overt step toward the commission of the offense.
So it's interesting. If you look at, if you look at the dates, the dates, they say on January 3rd, 2013. That's when the conspiracy began. So the murder occurred on March 24th. So they're saying 3 months before, 2 or more people entered into an agreement, at least on or about January 3rd through April 2nd. So this is through after the fact. So, this is the cleanup, if you will, the swiping of, this is the deletion of her message. This is, the swapping out of the cards.
All of this begs the question, who is Greg Moore's alleged co-conspirator? No one is named in court documents, a detail that caught Zukerman's attention.
I'm just curious if the government's just holding back, or if they, are trying to get him to come forward and make a deal and spill the beans. I don't know why nobody is listed here as a co-conspirator, but nobody is listed as a co-conspirator, and that was, to me, that was interesting.
We're going to demonstrate a pattern and some abnormalities that are driven from electronic messages, as well as different digital footprints that are left by different kinds of devices. It will all prove up beyond a reasonable doubt that the defendant did commit this murder.
We've shared this before. It's what Ohio Attorney General Dave Yost told us in episode 6 of this podcast. Yost oversees the state's Bureau of Criminal Investigation, which has helped amass more than 60,000 pages of documentation and several terabytes of information on external hard drives, all of which has been turned over to Greg Moore's defense team. So AG Yost has an idea of what's to come. Larry Zukerman is no stranger to how digital footprints can affect a case. He's currently representing a client who authorities say was the victim of ethnic intimidation and aggravated menacing. Authorities also accused the defendant of tampering with evidence, in this case, a cell phone that had video and texts related to the case.
They seized the phone, and then they had a forensic extraction. And so not only were they able to find that video, but they were also to found erased text messages.
As of this recording, the outcome of that specific case is still up in the air. What's crystal clear is the crucial role digital forensics plays in court. Recent filings to extend discovery in Moore's case from October 1st to December 31st call out at least one electronic device owned by a Stafford employee that BCI was able to extract and download. Prosecutors wrote they didn't ask for that extension lightly because, quote, it would necessarily extend all future dates in the case. Without opposition, Judge Krivosh approved the request.
Digital forensics, it's beautiful, wonderful, and absolutely frightening all at the same time. If people knew what you could find, people think, oh, I deleted the message to my girlfriend. There's only one way to delete items from a hard drive. It's with a hammer. That's it. There's no delete. And people buy these scrubbing devices. It's a waste of money. These forensic extractions are amazing. They get everything from a phone in an hour.
Two people who know better than most are digital forensic analyst Anthony Gentile and technical operations manager Jake Green. Both work at Invista Forensics, a U.S. firm that provides comprehensive forensic consulting and engineering services to clients, and often defendants, around the world. Gentile and Green both have law enforcement backgrounds and a wealth of experience when it comes to digital forensics. They've worked alongside both Ohio BCI and defendants in the state to prepare for other trials. As you might imagine, their knowledge of digital forensics bleeds into everyday life. This is Anthony Gentile.
Every time I talk to someone, they want to know, hey, what do I need to do? I say, well, first off, why are you asking me that? But if you want to know how to get away with a crime, I'm not putting out that information, but I will say that, your phone is tracking you at all times.
No surprise there, right? But what he offered next opened our eyes to something that might prove to be relevant in Greg Moore's trial. We'll unpack it all in the next episode of Aliza, Her Story.
Their response is, well, I would just turn off my phone if I was going to commit a crime. And so I say, okay, yeah, that's a great way to keep yourself from showing where you are. However, what we're seeing a lot of times is that the absence of activity can be just as important as activity.
Aliza, Her Story is produced by the Cleveland Jewish News. Executive producers are Kevin S. Adelstein and Jennifer Sherman. Today's episode was produced by Mike Butts, Courtney Burns, Stephanie Holmes, Bob Jacob, and me, Sarah Zukerman. It was edited by Stephanie Holmes and written by Mike Butts and me. Cover art designed by Bella Bendo and Jessica Simon. Our theme music is Particles by Nobu. Additional music in this episode is by Lance Conrad, Simo, Nobu, Stanley Gurvich, and Merrick Chikubowicz. News audio courtesy of WKYC 3 News. A clip from the film A Few Good Men is credited to TNT and Warner Brothers Discovery. To learn more or to support the Aliza Sherman Fund, visit give.ccf.org/Aliza Sherman Fund. To read more about Aliza's story and listen to other episodes in this series, visit cjn.org/podcast. Be sure to subscribe so you don't miss an episode. Thanks for listening.